Are you an okay student, a good student, or a great one? Here's how examiners figure it out. Hi, and welcome to the Law Simplified. I'm Shaveen Bandaranaike. When you look at answer scripts or responses to fact pattern or essay questions by students across jurisdictions, something that I have personally figured out over the past 8 years of lecturing and tutoring as well as mentoring students is that it's very easy over time to discern the okay students or even the good students from the great ones. There are characteristics which help distinguish those little nuanced differences that make the biggest differences when it comes to grading of these students. If you like the type of content that I make and you feel that it has helped you out in your academic as well as professional careers, do subscribe to the Law Simplified channel. Along with that, I highly recommend for any student who's following their LLB, GDL, or even a master's program to enroll in the online law school platform, complete with comprehensive theory, tutorial, and workshop lessons based on the actual one-on-ones that I have conducted with students that have gone on to achieve first-class law degrees around the world. Now, the fundamental characteristic of a great law student, at least the ones that I have come across over the past several years, is their ability to see that which other students, or for that matter even academics, might not be able to see. Articulating responses based on the law that they have studied, the facts that they are presented with, and honing in their technique in terms of articulating responses with arguments that are outside of the normal realm anticipated from students is how you go from not just passing an exam but acing one. This particular video is intended to show you one specific characteristic that I have noticed in great students, those who have not only gone on to achieve first-class law degrees, but also achieve well in their career pathways as well. Now, to do this, I'm going to have to use one particular principle in tort law, because it is by and large the best way to showcase the outlines and what's necessary for you to go from being okay to good, and more importantly to great. So let's have a look based on an argument you can formulate by using a particular case, the principles to it, and what you're expected from an analytical perspective to gather from it, to apply to a response. Let's have a look. For this example, we are going to have a look at the principles relating to identifying and allowing a claim for a secondary victim in terms of negligence. A quick TLDR, essentially a too long didn't read. A secondary victim is a person who has suffered some form of psychiatric injury without being in danger of having suffered physical harm or actually having suffered physical harm. There are a slew of precedent cases in English law that relates to this area. We are not going to look at substantive components of that. What's relevant to us in order to identify the difference between an okay student, a good student, and one that is great is based on the principle that in determining the value of a claim, a court will generally look at the proximity of space and relationship to the primary victim. Essentially, how near this potential secondary victim was to the scene of the accident or the injury sustained by the primary victim, as well as, more importantly, and as we will look at in a bit, how dear or how emotionally attached or proximate the secondary victim was to the primary victim. Now, to illustrate this point, I'm going to use a particular case, the facts of which are found easily when you do a very simple online database search or a legal database search or even a simple Google search, which is McLaughlin and OBrien. Now, the brief facts of McLaughlin and OBrien is essentially the fact that you had a secondary victim, a mother, who heard about her husband and 3 children being in an accident. Unfortunately, one of those children also dying from that accident, but saw the victims or the primary victims at the hospital after the fact. Essentially, the defendant claimed that since the secondary victim, the mother, did not see the accident occur or the injuries being administered on the victims, she would not have a claim since it fails the proximity of space, since she was nowhere near the accident. In the first instance, the defendant was successful, but on appeal in the House of Lords, the court essentially determined that no, there was proximity of space and time in relation to the geographical location. Now, from the perspective of an OK student, someone who is able to perhaps match a factual scenario that's been presented in an examination to the actual case law, you would see such a student essentially narrate or outline the facts, just like I did a moment ago. So, talking about the fact that the claimant saw the loved ones at the hospital before being treated, and the fact that the secondary victim, the mother, suffered a shock, depression, and some form of personality change. This potentially means that using the facts of the case to map out the factual or the fact pattern scenario presented. If you go one step further to identify a good student is one who essentially relates not just the facts but also the principle established by this. Now, one could argue that the principle is attached to the case, and if you read the case, you'd be able to implement it, and quite rightly so. But essentially, how an examiner distinguishes an OK student from a good student is if, in this instance, the student was able to identify that the reason why or the rationale for the court to determine there was proximity geographically or in terms of space and time is because the mother, the secondary victim, actually saw the victims, the primary victims, in the immediate aftermath of the accident. Essentially, the victims were not cleaned up, they were not treated, they were in the same state that they were at the time of the accident. So physically they might have been in a different location, but the mother saw them no differently to being at the time of the accident itself. Now, this is an indicator of a good student, someone who is able to extract the principle and the value of how the court determined what they did. Now, from this point onwards, what distinguishes a good student from a great one is where your opinion and your argument comes into play. Whether you are able to see this situation, the facts on the one hand and the principle the court looked at, and then determine, based on all of the other precedent case law and your understanding of the law in general, the fact that between nearness and dearness, in other words, when you consider the requirement of being close to the primary victim when this accident occurred, and emotionally proximate, close in terms of relationship, while up until this point you would generally think that both are required, this case in particular and this principle in particular showcases the policy of court and judgments by that measure that there is a prioritization of dearness over nearness that takes place. In other words, the fact that court is likely to overlook certain nuanced problems technically with nearness not being present as long as dearness is. Now, this particular analytical thinking is seen even in the judgment. The fact that the court and the learned justices went out of their way, so to speak, in trying to establish the presence of nearness and what the undercurrent of that, the fact that you might not see on the words themselves or the judgment itself, is what the examiner expects the students to discern and extract from. Namely, to analyze the fact that between the two, essentially, you could consider that judgments and precedent case law indicates that dearness is prioritized over nearness. Right. This particular example took one very specific scenario or situation, particularly in relation to a case and the principle of it, to show you how not only knowing the facts, or even the principle for that matter, is what is anticipated from a great student, but one where you go beyond that and make up your own mind, so to speak, on what that means broadly as well as specifically in a nuanced way, in a granular way to the scenario presented to you, whether it be a fact pattern or an essay question. Now, I would argue that while this example was in the law of tort, it applies to any given scenario. What I wanted to impress on you is the idea that it's not just the case that's important, it's not even the principle that's important, but what an examiner wants to see is what you make out of it, how you see that particular case and the principle, and what you've understood that might be different and that might be much more argumentative than another student. As I've often said in this very YouTube channel, as well as the different platforms the Law Simplified is disseminated on, your grade and your achievement in a law degree or even professionally is only as good as the response marked before you. It is subjective after all, and the determination of your success is based on how well you portray your legal personality. That being said, until the next time that we meet, have fun, stay safe, and as always, obey the law.